Be ready. 5 seconds.
Vide the impugned judgment, the appellant was convicted for the offence punishable under Section 304B and 498A IPC. Vide the order on sentence, he was directed to undergo rigorous imprisonment for a period of 10 years for the offence punishable under Section 304B. For the offence punishable under Section 498A, the appellant was directed to undergo rigorous imprisonment for a period of 2 years along with fine of rupees 1000, in default whereof, he was directed to further undergo 3 months imprisonment. The substantive sentences were directed to run concurrently, and the period already undergo was also directed to be set off. A total of 9 witnesses were cited as part of the charge sheet, however, during trial, only 8 were examined. As per the post-mortem report, the cause of death was opined to be shock consequent upon 100% anti-mortem flame burns. The prosecution also examined brothers of the deceased. The inquest proceedings were proved through the concerned SDM, who also exhibited the statements the brothers of the deceased that were recorded by him. All the accused persons were examined under Section 313 CRPC. The present appellant, who is the husband of the deceased, denied having made any kind of demand for dowry or treated the victim with cruelty on account of any such demand. He further stated that he was a victim of circumstances and a false case was fabricated against him. The other accused persons also raised similar defense and denied the prosecution case. Pertinently, vide the impugned judgment only, the present appellant was convicted while the other 2 accused were acquitted. Concededly, the state has not challenged the acquittal. In the present appeal, learned counsel for the appellant contended that there was considerable delay in registration of the FIR. It was argued that the said delay, along with other instances like omission to mention the name of any eyewitnesses, created serious doubts upon the prosecution case, as the said matter could be considered as being a result of deliberation and levelling of false allegations. It was next contended that the prosecution had failed to prove that there was any demand of dowry soon before death, and that ingredients of neither Section 304B nor Section 498A were fulfilled. In this regard, learned counsel has referred in detail to the testimonies of brothers of the deceased. Learned APP for the state strongly opposed the contention and submitted that the ingredients were established and proved beyond doubt by testimony of brothers of the deceased. Pertinently, in so far as the present appellant is concerned, 2 major incidents formed the basis for holding him guilty for the offence under Section 498A and 304B IPC. The first incident related to the appellant hitting the deceased with an iron press, whereas the second incident related to the demand of rupees 10,000 made by the appellant. While both the brothers of the deceased had deposed that the deceased was hit with an iron press by the appellant, however, it must be noted that their knowledge of the incident is hearsay inasmuch as they were not witness to the said incident. Stop.